Thanks, Kim. So, KW Commercial Session, thank you for joining us today. We have a pretty awesome session with Attorney Ara Sahelian regarding ADA litigation, but we're going to have David Yashar to introduce Ara. Kim, if you can spotlight David, because we cannot see whoever is not spotlight, I think. David.
Good afternoon, everyone. Can everybody hear me?
Yes.
Okay. Well, I'll keep this very short. Obviously, you guys all got a little bio of Mr. Sahelian. Ara, I've known him for some time, and one of the finest, the best attorneys out there on ADA. You know, and I've had the pleasure of working with him on, I think, 2 or 3 cases. And anytime I get one of these fraudulent lawsuits or get a letter, I don't do anything else other than pick up the phone and call this wonderful man. And we had Ara actually at a get together on March 2nd for I think Meny, you were there, a few others that joined us. He did a fantastic presentation in person. He's on today. We really thank him for his time. He's a busy individual, but he wanted to kind of go over the presentation via Zoom for the ones that were not able to make it on March 2nd. So Ara, thank you very much for joining us. On behalf of Meny, on behalf of Kim, the whole KW, the team that's on this Zoom, please go ahead. The floor, as they say, is yours. And I'm going to go mute or perhaps may sign off. But I will tell you this, anyone that does ski, make sure you come to Jackson Hole, Wyoming. Best skiing over 500 inches. And I will be returning back this evening. So without any further ado, Ara, please go ahead.
David, are you having moose steaks tonight?
Actually, I've been keeping it vegetarian.
No.
And, you know, but fish and vegetarian, but it is a great place to have, you know, beef steaks and things like that.
All right. So how many participants do we have in the audience today?
So far, you have about 14 people.
14 people.
All
Okay.
joining, yes.
Very good. All right. So I'm going to hopefully, I know this is right after lunch, so I'm hopefully going to make this as exciting as possible for you guys. And out of the 14, I'm assuming most of you, if not all, are work in the commercial space. Am I correct? Is that a yes?
Yes.
Yes. Okay. Excellent. So, so the litigation that you're going to be, or your clients are going to be exposed to, are all covered here. I'm gonna break the presentation into 4 sections. Part 1 is something I added recently. It's got graphics that make understanding the fundamentals of the ADA a lot easier than has ever been presented ever. And I put a lot of time in having all the graphics created. They were created on 3D and were able to give you different views of someone in a wheelchair in specific locations. So if you'd like, let's move to part 1 and I can show you what I'm talking about. All right. So we're going to start with a fictitious restaurant. As you can see, the restaurant has an outdoor and an indoor area, and it's got a parking lot outside. It's got 2 levels of dining, and what you cannot see is that there are restrooms on one side, and we can see that later. And we're going to cover what all the requirements are, for instance, for a restaurant, and the same requirements would apply to any commercial retail property, such as, say, liquor stores, department stores, shopping centers, whatever. So let's move on to the next slide. All right. So whether it's a parking structure or outdoor parking, what you need to have is obviously accessible parking spaces and with an accessible aisle. For those who are not familiar with the terminology, the accessible aisle is the crosshatched area, and your first accessible aisle has to be at least 8 feet wide. And the reason for that is when someone who uses a wheelchair and who uses a van, an accessible van, arrives, that person is going to need the space to extend the ramp from the van so that he can exit, or he and she can exit the van and either make a left or a right. So you need that space. You can't have cars parked right up to the van, then they naturally would not be able to get out. You would also need a transition from the parking onto the sidewalk. As you can see, there is what is called a built-in curb ramp, and it gradually helps the wheelchair rise to the sidewalk level, and it's got flared sides to prevent the wheelchair user from essentially falling off. And then what you have, obviously, are the entrance doors. So let's go to the next slide. All right. So the key features at the entrance of any business, whether, like I said, it's a restaurant or any type of retail store, if the doors are generally kept shut, you're going to need a flat sidewalk in order to prevent the wheelchair from sliding backwards, and also to make it easy to open the door. Now, remember, as the person in a wheelchair is pulling on the door, there's going to be a tendency for the wheelchair itself to move forward. So it's a delicate balance. If the wheelchair user pulls on the door too hard, and then the wheelchair lunges forward. So it's a little tricky in that you have to hold the wheelchair wheel forcefully with your left hand and pull on the door with the right. So the key here is having a flat surface in front of the door, having the door not be too hard to open, no more than 5 pounds in pressure, and then having the door wide enough so you can slide a wheelchair through. Next slide. All right. Obviously, before COVID, we didn't have too many takeout counters at restaurants. Today we do. So the takeout counter has to be reasonably accessible as you enter the restaurant. In other words, there can't be any obstructions. It cannot be too high. And next slide. As you can see here, the point of sale device has to be reachable. So the key, once again, is the service counter cannot be too high, and the credit card reader has to be reachable. Next slide. All right, once inside the restaurant, or again, any retail establishment, wheelchair user needs to be able to go from one end to the other. For instance, from his or her table all the way to the restroom and back, or be able to exit in the event of an emergency. So there has to be at least a 5-foot clear pathway throughout the establishment. Next slide. For restaurants, some, but not all, wheelchair users require a dining table that is clear below the dining surface. The key there is to have at least 1 out of 20 tables be an accessible type table. Next. The condiments bar. I've had several trials on this issue alone. It has to be accessible. If it's accessible to the general public, and then it has to be accessible to the wheelchair user, in that it cannot be too high or cannot be difficult to reach the condiments at the back. Next slide. The bar experience. I see this all the time where either a pool hall or a restaurant has a very nice bar, beautiful marble, this, that, but no accessible seating. In general, you have to have a section that is lowered that can accommodate not only the wheelchair user, but a friend that he or she brings along. Next slide. Outdoor dining has to be accessible as well. Now, I've had a number of cases where the restaurant does not have outdoor dining tables, however, has indoor dining tables that can be brought out. And I'm speaking, I'm focusing on accessible tables here. Judge Dale Fisher, she's a district court judge, ruled along with my client a couple of years ago in that she said, it's okay if the restaurant owner does not have an accessible table outside. So as long as there are accessible tables indoors that can be brought out for the person's use. We have a number of cases today, at least a dozen that we're handling here in the office, and they involved this same issue. The plaintiff did not see any outdoor dining tables, rolled by the restaurant and turned around and sued. The plaintiff should have stopped and asked for one to be brought out for him or her. Next. Again, this shows an accessible table placed outside for the wheelchair user in an area that is not isolated or in some corner and easy to go in and out of. Next slide. Restrooms, favorite topics for serial filers. So you see a lot of components here. You see the sink, the soap dispenser, the towel dispenser, the mirror, the grab bars, the flush control on the toilet, the trash can, and you see the space within the restroom. So let's start with the space within the restroom. There has to be sufficient space for the wheelchair user to be able to rotate naturally. Otherwise, if you can go in and you can't get out, that's not a good idea. There has to be, next slide, sufficient space for the wheelchair user to slide his or her knees under the sink, to be able to get the soap, to be able to manage the controls on the sink, and to be able to see himself or herself in the mirror. And naturally, you will see right below the sink, the drain pipe is insulated. While I honestly don't see any reason why it needs to be, because, you know, in 99.9% of circumstances, it cannot get hot enough, but I've seen litigation brought on that issue alone. So make sure that your drain pipe is insulated. Next slide. What I'm trying to show in this slide is how wheelchair users transfer. Some are able to transfer sideways, and the next slide will show how they transfer directly. But remaining on this slide for a moment, you'll see the seat liner also at a level at which the wheelchair user can reach and pull one out. Next slide. The wheelchair user that is able to transfer this way, the front transfer method, is one who could probably stand for a moment or two. So the technique involves standing and rotating and then sitting and then doing the reverse. So what you want here, as far as the grab bars are concerned, as you can see, there's a grab bar in the back and a grab bar on the side, is for the grab bars to be high enough, generally between 33 and 35 inches, and not too far away from the corners and far enough so that they're usable. And all of these dimensions you can are available to you online. I didn't want to give specifics here in the event they change occasionally. These regulations do change. Next slide. Okay, we spoke about how tricky it is to be able to open doors when you're in a wheelchair. So the way this wheelchair is positioned right now, it's impossible to open the door because as you open, you'll be hitting your wheelchair. So next slide. What a wheelchair user generally does is park to one side of the door and as I said, restrain the wheelchair and pull on the door at the same time. It's a delicate balance, and if the door is too difficult to open, then you've got a problem. No more than 5 pounds, as I indicated earlier. Also, if you have obstructions like a trash can near the door, that's going to be a problem. That's another source of litigation. Do not put a large trash can next to the door. Next slide. All right, part 2. There are ways of limiting litigation, easy ways, and these are the low-hanging fruit that serial filers essentially go after. And when I say serial filers, by the way, I can give you some names. You've got Scott Johnson up in the San Francisco area who's filed 6,000 lawsuits. Yes, you heard that right, 6,000 lawsuits. You've got Brian Whitaker, who has filed close to 3,000 lawsuits, and he's not limited to Southern California. He travels back and forth to Sacramento, San Francisco, areas in between. He's very liberal with his transfers. Then you've got Chris Langer, who likes to stay around San Diego. He's filed about 3,000 lawsuits. You've got Orlando Garcia, who was mostly in Southern California, but recently, and I say in the last year or so, he's traveled up to San Francisco and become very famous, made his way on television up there. And now he's back in Southern California. I've got a couple of trials with him coming up. Let's see who else. And then we've got several others, but none come close to the number of lawsuits these individuals have filed. Next slide, please. All right, low-hanging fruit number 1. If you are not diligent about restriping your parking space, you're going to get hit. This is so easy for a serial filer. All he or she has to do is drive by, see the faded marks, and allege that if he were to park there, he would be, shall we say, anxious because someone might come and park next to him because the lines are faded and it's not clear whether that's an accessible space or not. This particular case that you see here, I was able to dismiss without paying a dime. Unfortunately, it took about a couple of years because these guys thought I would give up, but I didn't. Next slide. All right, I get this all the time. The Manning firm and the Hakimi and Shariri law firm are notorious for doing this. They will find a parking lot that has a little crack in it, and they'll file a lawsuit claiming that the serial plaintiff suffered anxiety trying to walk over a crack and consequently is entitled to $10,000 in statutory damages. I had an interesting case come up recently where the plaintiff filed an identical lawsuit about a crack and a slight depression in the asphalt. And on the second day of trial, we were able to videotape her walking from the Norwalk courthouse parking structure all the way to the courthouse itself, and walking over cracks that were 3 times wider than this with her attorneys following her. So that video will make its way to trial. At this point, for technical reasons, the trial was delayed for about 6 months. Next. All right, we talked about transitioning from the asphalt to the sidewalk. What you see in the photograph above is a protruding curb ramp. That used to be allowable under the code. Unfortunately, it is not today. It's really, in my opinion, no one suffers difficulty and discomfort with that. You really have to be completely not paying attention if you're in a wheelchair to somehow fall off that built-up curb ramp. But avoid it because it's an invitation to a lawsuit. Try to go with the design below, which shows a curb ramp that is built into the sidewalk. And of course, that yellow material that you see is called a truncated dome. And there's a law firm that specializes in the area. In the truncated dome lawsuits, they have a few, shall we say, visually impaired clients who they bus around and later file lawsuits. We can talk about that privately if anyone has a similar lawsuit there. Next. Okay, if I could see your faces, I'd ask you what you see wrong in this photograph, but I'll give you the answer. There is no access aisle. There is a handicap spot. You can see the blue marking, but there's no cross-hatched area. So there's a likelihood that someone can park right next to the handicap spot and block the exit of a wheelchair. So that's an invitation to a lawsuit also that can easily be avoided. Next. Okay, slopes. Oftentimes you'll have a parking lot that is on the side of a hill, and that's a problem. I had a situation like that in San Francisco. As you know, it's pretty hilly up there, and ultimately we came to the conclusion that it would cost several $100,000 to flatten the parking areas, and we came to an arrangement with the judge that it would be impossible to do it. But that's an exception. In general, here in Southern California, most parking lots can be made flatter. But I generally take these cases to trial because the serial filer that claims that a slight slope has caused him or her difficulty or discomfort is not generally being honest. Those slight slopes are really not a problem. Next. This is another source of litigation. You can see in the lower right half of the photograph a blue striped path of travel from the sidewalk to the shopping center. And you don't see one similar to that in the upper left-hand corner. And while this is not a, shall we say, clear requirement, again, it doesn't take much for the serial filers to find an excuse to sue. So it's best to have some sort of a path of travel designated as far as reaching any building. Now, I had an interesting case recently in which the plaintiff, who weighs 225 pounds and her wheelchair weighs 300 pounds, so she in total weighs 500 and some pounds with her wheelchair, complained that there was no path of travel and that her ride was very bumpy along the asphalt. And I asked her, okay, how did you suffer difficulty and discomfort? And I am not kidding you. This is what she testified under oath. She said her rear end got a rash from traveling across a bumpy parking lot. So that case will be going to trial very soon. Next. All right, you see this scenario in a number of historic areas of Los Angeles where the entrance to a store has a step. And it's, in my opinion, and I'm taking this particular case to trial, so long as there are alternate accommodations available to the wheelchair-bound customer, then it's not a problem. As you can see in the upper photograph, you have a folded ramp, and in the lower photograph, you can see the ramp extended for the use of the wheelchair customer. So long as there's someone there to bring the ramp out, then it's not a problem. Next. Okay, so we have a number of serial plaintiffs, or Orlando Garcia being one, Antonio, I believe it's Antonio Fernandez or Fernandez. His specialty is suing every liquor store in Southern California, and he must have 1,000 bottles of liquor in his apartment, given how many of these places that he sues. But the liquor stores are sued for two reasons. The service counter, these filers allege, is too high, or the circulation aisles are too narrow. Here, what you have is what looks like, if each of the floor tiles is 12 inches, you have a 36-inch circulation aisle. If they find one that's 35.5 inches, that's a good enough reason for them to file a lawsuit. And frankly, I will challenge each and every one of them, because most wheelchairs are no more than 26 inches wide, and there's ample clearance to get in and out of these circulation aisles. Next. So I discussed service counters. By law, a service counter has to be 36 inches, but the plaintiff also has to show that if the circulation, strike that, if the service counter is too high, then he suffered difficulty and discomfort. So if you've got someone in a wheelchair who's tall and whose arms extend and who's not really carrying something heavy, then judges are not likely to believe in their story. And I had a similar situation with Mr. Whitaker, Brian Whitaker, who I said has filed close to 3,000 lawsuits. He alleged that he went to a Mexican restaurant to pick up a burrito to go, and that he suffered difficulty and discomfort carrying his burrito. And the judge didn't believe it, because throughout the entire trial, he had his arms up in the air and he was waving. You'd think he'd have the sense to keep his arms down if that's what he's alleging. But what you see here is a case that I took on pro bono, and I litigated for close to 3 years. The Potter Handy law firm had sued actually a single mom who was raising a disabled child, and I found that to be unthinkable to be doing that. This single mom was operating a used clothing store, and what she had was a pull-out service counter, as you can see on the right, and it was at the proper height. But unfortunately, on the date of Mr. Whitaker's visit, it was covered by as you can see, there is a hanger on the left side with a bunch of clothes on it. That was on the right side, and it was covering it, and he didn't see it. He didn't even ask for a lower counter. He just turned around and sued her. So what happened at trial in the afternoon on the first day of trial, about 3 o'clock, the judge called us into chambers, and this is not a joke. He said, "I don't understand this. I don't understand the ADA. I don't understand this case. You guys have to settle it." So we settled it for $3,000, despite the fact that their demand was over $17,000. Next slide. All right. This looks like, yeah. So we're going to stop right here because this is going to be a repeat of some of the things that I said. Next slide. Let's see what I have. And then next one after this. Okay. I would say a good third of the lawsuits that I have right now that are going to go to trial have to do with restaurants, unfortunately, who were caught by surprise because they had the center pole type tables outside instead of having a table that you see in the center of your screen. That's the ideal table to have. Now, the center pole table for 90% of wheelchair users is not a problem. They're able to pull in and they're able to dine quite easily. But again, it doesn't take more than a little excuse for these guys to sue. And so the moment they see one of those, bingo, it's a lawsuit. It's a $12,000 to $17,000 demand. I have, as I said, a number of those cases, and I intend to bring up the fact that a federal judge already ruled that if you have one or more accessible tables indoors that can be brought outside, then the plaintiff does not have a claim. Next. All right, website litigation. I don't know how many of you have their own websites. I have one simple recommendation for you. Let a professional do your website. Don't do it yourself. And let a professional test your website to see if it's readable using a Mac and a PC. A Mac and a PC each use a different method for converting text into audible material. So a Mac will use a feature called a voiceover. You've probably accidentally pushed a voiceover button once or twice, and you know what I'm talking about. All of a sudden, your phone will start reading whatever is on the screen. So it's important, if you have a website, that everything is properly labeled, that the buttons are properly labeled, that the visually impaired user can go from one navigation button to another, can navigate the menu items and so on, particularly if you're the owner of a small restaurant. Let a professional do it and let a professional test it. For PC users, there's a software called JAWS, J-A-W-S, and most visually impaired plaintiffs use JAWS in order to be able to navigate. It reads the screen for them. So I had something really interesting happen last year. There was a, in fact, if you guys are interested, there was an article over the weekend in the Miami Herald, and discussed a plaintiff whose name is Andre Gomez. And the article mentions me in that I was able to dismiss 12 of Mr. Gomez's cases without paying a single dollar to him. So it's this weekend, the Miami Herald. So what happened was Mr. Gomez had sued one of my restaurant clients, and I immediately took his deposition and found out that he lives in Miami and he lives on Social Security disability, among other information that I got from him. And next thing I know, a few months later, he's suing several dozen Napa real estate brokers and agents because he alleged that he wanted to buy Napa real estate. So I immediately jumped into federal court. And as I said, I had 11 cases that I was defending. And ironically, each was in front of a different judge in San Francisco. So I was able to convince the first judge and then the second that Mr. Gomez had no intention of ever buying real estate, that there would be no need for Mr. Gomez to visit a real estate broker's office, because nowadays most real estate brokers or agents meet their clients at a property, and consequently there was no nexus between the website of an agent broker and their office. And in addition to the fact that Mr. Gomez did not have the means or intention to buy any property in Napa, so I was able to get all 11 cases dismissed one after the other. It took about a year, but got it all done. And Mr. Gomez hasn't bothered anyone in the San Francisco area since. He's back in Florida. I think he's active there still. Next page. So I mentioned this to you. We covered this, JAWS and VoiceOver. JAWS for PC type laptops and VoiceOver for Mac laptops and iPhones. Next. We covered this. Next. And we covered this. Next. I believe I covered this as well, all the navigation items. Next. So if you'd like to learn more about website litigation, there are a couple of experts that I use. They have a company called Accessible Crew, LLC, and they have a video posted on YouTube, and you can learn more about this area of litigation from them. Next. All right, so how am I doing time-wise? Do you want me to keep going, or do you want me to stop here?
Yeah, this is your last section, I think. So let's keep going.
Okay, has anyone fallen asleep yet, or is everyone still awake?
Yeah,
I guess not too many people have had the wine for lunch.
Right.
All right, so what do you do when you get sued? Number one, you don't panic. Number two, next slide. You don't hire your divorce lawyer for handling an ADA case. Okay, remember that. You need someone with experience, not only someone that understands this area, but someone who's actually gone to trial on these cases, because it's one thing to be making 2 phone calls and settling a case. It's another thing fighting these cases. Next slide. Before you make any changes to your property, take lots of pictures and dimensions, because it may just be that the plaintiff didn't suffer any difficulty because of the condition of your business. So, don't feel guilty immediately and think that you owe money, because you may not owe any money, and the condition on your property may not be shall we say, a barrier. It just be a minor, it could be a minor technical issue that is of no consequence. Next. Yep. So one of the things that happens all the time is someone gets sued and they immediately rush and fix whatever it is or make changes. And then the plaintiff's attorneys go to the judge and they say, see, we were right, judge, because you know how we were right? Because they went in and changed all of these things. So they knew they were at fault, and that's why they made the changes. So you need to coordinate whatever changes you're making with your attorney, and obviously not your divorce attorney. Next. Another thing is that you hear about are CASP inspectors. California has these certified inspectors who understand the ADA, and that's fine. I have an expert CASP inspector that I use all the time. I take him to trial with me all the time. But the key is, keep in mind, a CASP inspector does not understand ADA law. All they understand are the ADA standards. So they end up giving you legal advice, and they shouldn't, because they don't have the experience. They haven't been in front of judges, and they haven't read complaints. So keep that in mind as you're making changes to your property if you don't have a lawyer. Next. So if there's one thing to keep in mind here, if you forget everything else that I said, keep this in mind. Just because you have an ADA standards violation at your property, and I don't even like to use the word violation, I like to use the deviation. Just because you have an ADA standards deviation, it doesn't mean that you have to pay the plaintiff, because there are 3 elements to an ADA lawsuit. Number 1 is the deviation. Number 2, there has to be some sort of a connection between the ADA standards deviation and the plaintiff's disability, okay? What if the plaintiff, for instance, can walk using a cane? All of the regulations that apply to a wheelchair do not apply to somebody who walks using a cane. Same thing, a walker. Same thing, for instance, issues that apply to people who are visually impaired do not apply to those who are wheelchair bound. And the other thing that I bring up and try to convince judges is that no 2 wheelchair users are alike. Some are able to, you've seen athletes who are in wheelchairs. Some are able to play basketball or race, and others need electric wheelchairs that require batteries and motors. And by the way, speaking of electric wheelchairs, I have a couple of cases with plaintiffs who use electric wheelchairs whose seats can actually rise and drop 12 inches, yet they have the audacity to allege that the service counter was too high. How could they possibly have experienced difficulty and discomfort if their wheelchair rises 12 inches and the service counter just happens to be 3 inches higher than that required under the code? Next slide. So the elements of a case, which I touched upon just a moment ago, are slightly different in a federal versus a state case. In a federal case, if you want to maintain the case, if you're a plaintiff, and if you want to maintain the case in federal court, you have to show that you really, 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 really want to go back, and you're prevented from going back because of a particular deviation from the standard. Well, if you've got somebody like Brian Whitaker who lives in LA and who's suing every restaurant in San Francisco, why does he really, really, really need to go back to San Francisco to that restaurant? I had an interesting case with Orlando Garcia in San Francisco. He went up there and sued a butcher shop. And the judge said, you're staying in a hotel. What do you need to go to a butcher shop for? And so last year I was able to dismiss about 42 cases in the San Francisco area without paying a single dollar for this reason alone, the lack of imminent harm. Next slide. State court cases substitute the imminent harm element with a genuine intent to patronize the business. What you're finding nowadays is you get somebody like Anthony Boyer, who's represented by the Manning law firm. I took his deposition recently and he says, oh yeah, I went in there to get a drink and the slopes were too steep but here it is. I got proof. I've got a $5 drink. I've got the slip to prove that I was there. So, generally I asked them, so when you got out of the car, you noticed the parking lot was not to your liking, correct? Yes. It was perhaps the slope was too high in one direction or another. Yes. And you were feeling uneasy, correct? Yes. Well, I imagine you went back in your car and you left, right? Because you couldn't handle it. And the typical answer is, well, no, I figured I was already out. I might as well go in and get a drink. In the meantime, there's 5 other McDonald's around the neighborhood that would have given them a drink through a drive-through. So, a lot of these cases are brought not because the plaintiffs have a genuine intent to patronize. They're just looking for another place to shake down. Next slide. So I'm sure some of you have heard of the Potter Handy law firm. They file about 5,000 to 7,000 cases a year. And a couple of years ago, they shifted their operation to San Francisco. They took their serial plaintiffs who were filing mostly in Southern California, the Brian Whitakers and the Orlando Garcias, and they moved them up there. They would shuttle them back and forth. And their excuse was, at least Brian Whitaker's excuse was, he was shopping for real estate up in the Bay Area. And Orlando Garcia had that same excuse too. And isn't it interesting? Here we are 2 years later, they both changed their minds. And they're not interested in buying any property up in San Francisco after they've essentially ruined their reputations up there. And I'll take some of the responsibility on that. Next. Okay, I never settle a case without at least a deposition, because a deposition is going to expose lies. Now, I last week settled a case, and it's absolutely rare. There's just no way to defend it. It was a gas station with a tiny convenience store, and they had packed all kinds of imaginable furniture in there, whether it's an ATM machine or display racks or whatever. There was really no way to get a wheelchair in there. And it's, even if I get a jury to look at it, even if I'm able to prove the guy is had no intent to patronize, it's still a difficult case. That shouldn't happen. So that was a case I settled right away. But 99% of the time, I will not settle a case without taking a deposition, and a deposition exposes the lies. And I'll take the deposition right away. I don't even wait for written discovery. Next slide. As I mentioned earlier, I was able to get 12 Gomez cases dismissed, 11 of them in San Francisco against real estate brokers. And these are all the cases and the dates they were dismissed, all in 2022. So I think that's the last slide. My next one. Oh, typical serial filers that I'm dealing with today. Let's see. Roy Mason. Oh, what a character. He's alleges he's homeless, but when you take his deposition, you find out that he's rented a house. Scott Johnson, Mr. $6,000 lawsuits. The case I had with him, I've had several. The one that I love, I don't know if you guys are familiar, but if you're in a wheelchair and you go up to a gas station, all you have to do is honk the horn and someone comes out and pumps gas for you. But not with Mr. Scott Johnson. No, he wants to go out of his van and go inside the office and ask someone to come out and pump the gas for him. And if there is a step to go into the gas station's office, he will sue them. That's how absurd that lawsuit was. Brian Whitaker, we mentioned, Orlando Garcia, Perla Magino. Oh my God. Perla Magino has filed about 700 lawsuits against restaurants. She loves to sue small restaurants and small bakeries. She alleges that she is blind, which I'm sure she is. But when I took her deposition and I asked her if she had ever, after suing and settling these cases, ever gone to these restaurants to use their services or to eat there, or even if she had ever had food brought to her. And the answer was no. And the irony is, in each one of her lawsuits, she says she's being deterred from shopping at these places because she cannot read their websites. And she continues to file lawsuits. Same with Rusty Rendon. Mr. Duarte, I had an interesting case with him. He claimed he couldn't go to the restroom of a tire store because there were tires stacked in front of it. That wasn't his complaint. When I took his deposition, he swore up and down that not only were the tires out of the way, but he was able to go in and make a U-turn in the restroom and use the restroom facilities. Needless to say, that case was dismissed very fast. Next. Yes, so what I want to show here is that Mr. Johnson was recently nabbed by the IRS, and he had to disclose the types of money he was making with ADA lawsuits. As you can see, in 2013 alone, or 2014, he brought in $1.1 million. So as you can see, there's big money behind this, and the law firms profit immensely. And unless you know how to fight them, they will fight you and they will crush you. So you really have to have the experience. Next slide. And that's the end. All right, let me take a look at your questions. All right. As realtors, should we be concerned if our website is not ADA compliant? Absolutely. Have a professional take a look at it. And if you don't know any experts, contact my office. I'll put you in touch. Angela, thank you for the very interesting. Elizabeth, thank you. Elizabeth, again, thank you. Let's see. Oh, Christine, thank you for being awake. And Michael, wow. Okay, well, thank you. Do we have any questions?
Please feel free to unmute so you can ask your questions. So much information. Well, I have a question actually. The standards that you talked about, for example, for restaurants and some of the other retail locations, we can assume those apply to adults, right? Are there a different set of standards? Do you run across a situation where maybe parents feel that their child who might be in a wheelchair or something might be at a disadvantage or not have things set up right?
That's a good question. So if you're a child and you have your parents accompany you, you can't possibly suffer difficulty and discomfort because your parents are basically opening the door for you. You're not picking up takeout material. Now, however, if you have a restroom and the minor is in a wheelchair and cannot rotate or cannot transfer, those are issues that apply to everyone. So it's on a case-by-case basis.
Okay. Another question in the chat, will food delivery services such as Uber Eats play in future litigation?
So that's an excellent question, Elizabeth. So when somebody like Perla Magino says, well, she couldn't read the restaurant's website, couldn't look at the menu. My next question is, well, did you look at Uber Eats or some of the other websites that actually have duplicate menus that will actually process your order? And they'll say, no, I didn't know those existed, which is obviously not true. So in terms of, are they, for instance, is Uber Eats responsible for their website if you're unable to place an order through their website? I would imagine yes. I don't see any reason why they couldn't be sued if their menus were not readable or if you couldn't place an order through them using either JAWS or VoiceOver.
Another question about the restaurants. You said that ideally the tables would be not a center post, I think is what you called it. So if there's restaurants with round top tables that typically would have a center post, are wheelchairs typically able to pull up to the round top?
Excellent question. So if you have a small round top, it could be a problem. And it also depends on the types of feet that they have. Now, if you have a large round top, let's say 5 or 6 feet in diameter that allows several people to sit at, then the feet are generally spread and you'll be able, if you're in a wheelchair, you'll be able to roll underneath without difficulty. The other thing that you need to take into consideration is how high the feet are. Sometimes they are low, they're no more than 1.5 inches in height, and most wheelchairs will slide right over them. I had an interesting case with Brian Whitaker. The first day of trial, I brought in one of the tables he alleged he couldn't use. And I had an expert go and take his wheelchair dimensions. So I knew that his wheelchair could slide right over those feet. So the next day we show up for trial in Chatsworth. And what does he do? He actually, that night, he went to someone who lowered his footrest. And during trial, he showed that he couldn't get his footrest over those table feet. And I was able to show the judge that he had intentionally lowered them just for trial purposes. And he lost the case. Next.
Any other questions? Well, it definitely seems like there's people out there that will go to any extent necessary. Right?
Yes, so if you want to make a lot of money, go skiing like David Yashar and have a skiing accident, and then you can go around and sue 100 people and make lots of money.
Okay. Well, Ara, thank you so much for all this valuable information. It was really, really enlightening. I learned a lot, and I'm sure everyone else did. And we will have this recorded. So if you missed any parts of it, then we're going to broadcast this out for you. And I'll send you a copy as well, Ara.
Anytime. Happy to help.
Thanks so much. Thank you, everyone, for being here. And we'll see you in 2 weeks.
Thank you.
Bye.
Bye.